I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are dropping our 16th compilation video. And for those of you that are new to the channel or new to our compilation videos, first of all, I would like to ask you guys that are not subscribers to subscribe and to help you all to understand what our compilation videos are. They are throwback moments from previous proceedings that we've shared here on the channel. And today I'm going to be sharing 4 different proceedings out of 4 different judges' courtrooms. But another thing to know is these are going to be small portions of larger proceedings. So what I'm going to do is I'm going to have a link in the description where you can go and watch the full proceeding from these clips. Also, some of these proceedings actually had multiple appearances. So when you go to watch the full proceeding from these clips, make sure you go down in the description of those videos to make sure there isn't anything that you need to catch up on. Now, with all that being said, let me give you a rundown of the judges' courtrooms that we will be in on today. It will be 4 different judges. First, we will be in the courtroom of Judge Michael Olsaver out of the state of Michigan. Second, we will be in Judge Pauline Freund's courtroom out of the state of Washington. Third, we will be in Judge Tanisha Yancey's courtroom out of the state of Michigan. And last but not least, we will be in Judge Kim Cook's courtroom out of the state of Texas. For those of you that are familiar with these compilations, you know that there will be no commentary at the end, and there will also be chapters added to these videos just in case you've seen any of these proceedings. With that being said, guys, let's go ahead and jump into these proceedings.
All right, we are on the record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
You are muted, Mr. Glazier.
John Glazier on behalf of Mr. Lester.
Mr. Glazier, where do we stand with Mr. Lester's case today?
Your Honor, at this point, I can't talk to Mr. Lester. He, when we try to talk, he just starts screaming and yelling at me and won't listen to anything I've got to say. There's been a plea bargain offered to him, but I can't even get a chance to get it into him. I'm looking back at my notes, and Mr. Murphy apparently had the same problem with him on September 21st. He said he was going to represent himself, and he ended up waiving it. And Mr. Murphy has notes that all he did is scream and yell at him, and he didn't like being trashed on the record by his client. If Mr. Lester doesn't want to listen to me, and I can't even get him to listen at all, Your Honor, all he wants to do is scream and yell. I told him I'd set it for trial. He didn't want to set it for trial. What he really wants to do is vent. Now, there are some notes that he may have some mental health issues, according to a family member. But if Mr. Lester doesn't want to talk to me, I don't know what to do other than just...
What did you just say? What did you just say? A family member did what?
Mr. Lester, please sit down and be quiet.
A family member called in and say you may have some mental health issues, which may mean we need to evaluate you.
My family member couldn't have. There's nobody up here with me but me.
Phone call.
There's no one here but me. And if you have a name, please let me have it with a phone number, because I've been trying to call my family for the past 3 months, sir. And on top of that, Mr. Salvatore, understand something, Mr. Olsaver? Let me say something, please. Can I say something?
All right, both of you stop talking right now.
Okay, that's fine. I'm willing to listen, but this is getting ridiculous.
Mr. Lester, I said stop talking, continuing to talk. If you continue to Mr. Glazier, stop talking. That is not a difficult instruction.
Wow.
And I am not going to lose control of this proceeding.
I appreciate that. Thank you.
Mr. Lester, I've muted your device. I instructed you to not talk 2 times, and you continue to talk. I can't hear what you're saying. You're on mute. Mr. Bayanetto, is there a plea offer in this case?
There is, Your Honor. Mr. Sneed extended a plea offer to Mr. Glazier of a plea to attempted possession of methamphetamine and the 2.
All right, Mr. Bayanetto, I'm going to interrupt you for a moment. Mr. Lester, you unmuted your device. I am muting it again. If you unmute it, I'm going to hold you in contempt. I'm sorry, Mr. Bayanetto. What is the plea offer?
That's okay, Your Honor. The plea offer is attempted possession of methamphetamine and then the 2 RNOs as charged. I believe Mr. Sneed would also be dismissing the habitual offender notices as well. No habitual offender notices, and with an agreement to no MDOC time.
All right. So, Mr. Glazier, are you asking to have Mr. Lester reviewed for competency and/or criminal responsibility at this point?
I guess I'd still like to a chance to talk to him when, Your Honor, if we do that, it's going to take at least.
All right, I'm sorry to interrupt, Mr. Glazier, but I'm just trying to keep a record of what's happening. I thought Mr. Lester had left the room, but he's not. He's still here. So I'm sorry. Continue.
Those evaluations will take at least 90 days to 120 days. The prosecutor further indicated on this that we could address bond, which I have set for this afternoon, but the prosecutor had indicated he'd have no objection to a PR bond if we get this matter settled. I need to speak with Mr. Lester, but and see if he can calmly talk about this plea bargain with me.
Mr. Lester, I'm going to send a request to unmute your device. Is there an officer that's there with Mr. Lester that can unmute that device at the jail, please? Mr. Lester is apparently talking to someone. I cannot see who that is that he's talking to. Is there an officer at the jail with Mr. Lester?
Yes, sir.
Yeah. That's it.
All right. Thank you for unmuting that device. Mr. Lester, did you hear the plea offer that's been made by the prosecutor?
I don't even understand what that means. What are you talking about as far as it goes? Is he
I'm asking.
Can I finish?
I'm asking you whether you heard it or not.
Did I what?
Did you hear the plea offer made by the prosecutor?
Kinda. All I know is something about a no habitual attempted
All right.
this, that, and the third. I don't understand what that means as far as that goes. What is he offering? No jail time, probation?
Do you want to talk to Mr. Glazier to get an understanding? He can explain.
I'm trying to, man. I haven't talked to this man in 30 days. 30 days, Your Honor.
Mr. Glazier just said he would like to talk to you to explain that offer to you. but you need to be able to sit and listen to what he says. Do you want to do that?
Being railroaded, what am I supposed to do? Yeah, I'm willing to do that.
You're not being railroaded. I'm asking you whether you want.
Can I talk to Mr. Glazer?
All right, Mr. Lester, if you're not going to participate and answer my questions, I'm just going to set this for another.
Yes, bro. I don't know how many times do I got to say it. Let me talk to Mr. Glazer, please.
Okay, thank you. That's the first time you've said that. So I will set up a breakout session for you with Mr. Glazer right now so that he can explain the plea offer to you.
Ernie, man. Oh.
And we have Mr. Glazer and Mr. Lester back from the breakout session. Mr. Glazer, where do we stand with Mr. Lester's case at the moment?
I don't want him no longer represent me, sir. Can we get somebody else, please? He's trying to, and he belittled me and wrote notes, him and Mr. Murphy. I would like to get somebody else, please.
Mr. Lester, I only have the ability to appoint the public defender's office. So
okay, but not out of their office.
Mr. Lester, stop interrupting me. I'm trying to explain to you that I only have the ability to appoint the public defender's office. I've done that. We've been through 2 attorneys now that you have not liked. You don't have the ability to pick your public defender. One has been assigned to you. If the public defender's office chooses to make a reassignment, that's their business, but I cannot make them do that.
Okay, that's fine, but I still don't want him to no longer represent you, Mr. Olsaver. I want you to see what's going on for yourself before I make any decisions. That way you see it for yourself, Your Honor. I'm not trying to sit up here and go back and forth with Mr. Glazer because there's certain things that I've asked him to do that he won't do. One being that there's prior footage camera that he won't even subpoena, for one. And then on top of that, it started on August 2nd, but I was arrested August 4th. So they harassed me for 3 days. He also was supposed to get the transcripts that he does not have that I had to send off for myself. He hasn't came down here to talk to me. Every time that he says he does, this wind up happening. This is why I'm upset, Your Honor. It's because I'm not being able to talk to anyone. I don't talk to my sister because he just told me the fact that he talked to her that I have mental health issues. I have not talked to my sister since 2015 when my mother passed away because she put me in jail behind some BS in the first place. I had to hitchhike back home to Akron, Ohio, just to go to her funeral. So we don't talk. And Mr. Glazer continues to sit up there and belittle me and slander my name to you, him and Mr. Murphy taking notes when they know what they're doing. That's a conflict of interest. That means they're talking behind my back. There's no way this is going to work between me and him. He's sitting there.
Mr. Lester, I'm just going to interrupt you because I want to correct one point.
Okay.
Mr. Glazer has not said anything to me that has not occurred on the record about you or about your case. And so to the extent that you've just said that Mr. Glazer is somehow communicating with me about you and
I said Mr. Murphy,
that is
sir.
Incorrect. That is false, sir.
I said Mr. Murphy, not Mr. You. I never said
the same goes for Mr. Murphy. All
yes,
right?
he did.
Neither
He
of
just
them
sat there and told you that.
Mr. Lester, do not interrupt me.
Wow. Lying on me, man. That's
my obligation. My obligation in these hearings is to create a record that can be. Do not unmute that microphone, Mr. Lester. Can you hear me? Shake your head yes if you can hear me. I need to make a record of these proceedings. That cannot be done when you are talking over me when I'm trying to explain something to you. It is disruptive to these proceedings and makes it impossible to create a record. And all this is doing is dragging things out and making it take longer. So I'm going to unmute your device once again, and I do not want you to interrupt me when I'm talking. And I want you to answer my questions directly when I ask them. Do you understand that? All right, go ahead and unmute the device. If you need help, you can ask the officer that's with you to unmute that device.
Guys, I don't trust none of y'all. I swear to God.
All right, Mr.
I don't trust none of y'all.
Mr. Lester, all right, at this point, I don't think Mr. Lester is in a position to be able to continue this hearing. So I'm going to adjourn this hearing to next week, November 8th at 8:15.
We are on the record. Thank you for asking.
Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on
You don't
stand.
have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer,
I'm
please,
not going to do that. What's the basis for that?
because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates,
Correct.
which will prolong my time in jail,
I don't know that.
possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail. I'll do my best to work with this guy.
Okay.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for?
I'm gonna write a letter to to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send two different letters?
Yes,
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
you have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send one letter. They, in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, what, can you tell the jail, give me sufficient paper so I can make 2 copies? Because they're not giving me the what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati, and then he can make copies for both the court and the city.
Okay, Mr. Ionetti, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionetti.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans, and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. McCoy Sr. He believes that they're all witnesses for this case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ionetti if he's doing any.
Sir, you can't get restitution. I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal, there's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
No.
And not even my rights as a tribal chief.
You have asserted that you are a tribal chief. I have seen no evidence of that being true. Just because you say it doesn't make it true.
I gave you the proof, but you needed the physical case in front of you, which has a seal on it. So even if it's in front of you, you still won't be able to see that I'm a tribal chief based on having a case in front of you.
It's my understanding that Mr. Ionati was able to obtain that document.
Correct, which is a matter of secret state privilege.
So you can't say it's in this document and then not let me see it.
I'm just stating facts. That case is a matter of secret state privilege. So that would be grounds would that be grounds to get it transferred to federal court?
The issue is whether you trespassed at the airport, sir. That's the only issue.
I understand, but as a tribal chief, I have the right to have any grievances between me and the state heard before the United States Supreme Court due to me representing a sovereign state that's federally and internationally recognized, a sovereign tribe that's federally and internationally recognized.
You won't tell me the name of the tribe. You won't show me the document.
It's a matter of secret state privilege, Your Honor.
You can't have it both ways.
I'm just stating facts. It's a matter of secret state privilege.
So no, as I understand it, the city is not willing to transfer this case to federal court.
Mr. Ionetti, I would like to appeal Anything that's being declined, I just want to get this on the record that I want it appealed. Anything that's being declined, I want it appealed.
Sir, you represent yourself. It's up to you to appeal.
Okay, no problem. I'll send a letter out today with a notice of appeal to the Supreme Court of the state of Washington.
Appeals from courts of limited jurisdiction, which is what we are, go to Superior Court, not the Supreme Court.
But I'll try to speak to them based on the circumstances that I would like to oblige directly to the state Supreme Court due to the circumstances and the fact that it's connected to a matter of national and homeland security.
You're going to have to show them proof that that's the issue too. You can't just say a thing.
I will show them the proof. I will show them the proof with no problem. It's on them if they want to do their work and research and diligence to get the answers that they want, that they seek.
So
I will show them the
sir, once again, courts are not investigative bodies. They will do no research. They will not do an investigation. That is up to you.
I understand it. Exactly. And I'm doing an investigation on my behalf, and I'm providing everything that they're asking me for. They just don't like my answers. I'll deal with that on the federal level when I file a notice to remove once I get out of jail, because I can't do. Also, if Mr. Iannetti, if you can file a notice to remove with the federal courts or with this court, I would like that as well, please.
Mr. Iannetti, do you have any concerns about Mr. Evans' ability to proceed?
I do. I mean, I don't have anything to verify any of the claims that he has made and the information and who he's asking for as far as witnesses in this case lead me to believe that there may be issues.
Do you think it's appropriate to have him evaluated under 1077?
I do.
Does the city have any objection to the ordering of that evaluation?
I have an objection.
Okay.
Can I object?
You can object.
Yes, ma'am. I assure you that I'm 100% competent, and I assure you that everything I'm saying is true. As far as civil case 24012 out of St. James Parish, Louisiana, that is a matter of secret state privilege, and it also verifies the facts that I'm making that you guys claim you cannot prove.
But you won't let us see it.
Mr. Iannetti has to get the case himself.
He has it.
So tell him give it to you.
Can I identify the case, Mr. Evans?
Civil case 24012 out of St. James Parish, Louisiana.
Can I identify the case and the information that I have?
Like I said, you can give her civil case 24012 out of St. James Parish, Louisiana. If she wants to look over it, it has a seal on that case. So you're going to have to get permission to get that seal removed.
So it's my understanding
true content.
It's my understanding it does not have a seal.
That's the information that I have is it does not have a seal. It's a 1996 case, Blue Harvest Maritime versus Opal Evans. It was a suit for damages.
That's the guise that it's under, but the true contents of that case is under seal. I assure you.
And Mr.
I guarantee it. I'm not guessing.
Who can take it out of seal.
I'm not guessing. I'm guaranteeing it because I became the chief of a federally and internationally recognized tribe when my father passed in 1993, and everything was made official with that case in 96. I guarantee it.
So if it goes to me, it goes to the city as well. And are you okay with that?
I would like to have it sealed due to the fact that it's gonna expose innocent life.
It's a matter of public, sir. It's a matter of public record. And it's not filed under seal. I don't know what the justification is for sealing it in this court.
That it's gonna affect innocent life, including the names that he named that I don't want named with public to have public access to those names on that case and whatnot. It's definitely going to affect innocent life, and it's connected to a matter of national and homeland security.
Mr. Iannetti, what you were able to, what you have in your possession is a matter of public record. Is that right?
The information I just have is what the court clerk told me. She indicated that I can pay $1 a page for the file. They weren't able to tell me how many pages were in the file. They said it was archived based on the age. It is, I mean, it is a state court. And they indicated it was a suit for damages and not consistent.
It's connected to my estates that I have, plural. Is it all making sense now?
No,
And there's only, Mr. Evans indicated that there's something in the file that's only one person has the ability to unseal, which
And
is
that's
not
Chief
consistent
Justice
with,
Roberts.
and that's not consistent with the way the law works. So
I'm
that's
the
my
rarity.
concern.
I'm the rarity in this case, I assure you.
Right there.
Yes. For the record, I am not a person.
Mr. Brown, do you have any questions for for Corporal?
Yes, he said the person, I am not a person, so I'm trying to figure out.
Do you have a question for for Corporal Spidell? Corporal Spidell, I'm sorry, Corporal.
That's what the officer now.
Do you have a question for the Corporal?
No, I don't have a question.
Do you have any questions for Corporal?
Not for court. I have a question for
You have a question for whom?
the court.
Okay, you don't actually get to ask the court anything unless you have a motion that you'd like to file. The court doesn't really take up any questions at this point. We're in trial. So at this point, if you would like to cross-examine the witness, you may do so now.
No, I don't have any questions for the officer.
Okay, so the witness is free to step down. Do you have any witnesses? I'm sorry, any further witnesses, Mr. Geringer?
People have no further witnesses and rest their case.
Will the defendant like to call any witnesses?
Speak for myself.
You would like to take the stand as a witness?
Yes.
Okay. Please raise your right hand. Do you swear or affirm that the testimony that you give will be the truth and the entire truth?
Yes.
Please state and spell your name for the record.
For the record, my name is Roman Brown. Living man. You said spell it.
Please spell it, yes.
Capital R, lowercase O M, lowercase m, lowercase n, lowercase n. Capital B, lowercase r, lowercase o, lowercase w, lowercase n.
Okay. And Mr. Brown, I'm going to have you give your testimony from the podium as you are representing yourself and you are now the witness as well as the acting on your own behalf as your own attorney. So you may proceed.
Yes, so I was traveling like, I'm a non-citizen national for the record. I am not a United States citizen. I am not a resident in the state. I live in United States of America. But I was traveling. I didn't commit any crimes. The officer asked me for his documentation. I gave him the documentations that were valid. The driver's license, he unlawfully detained me. I did not consent to any searches or seizures. He unlawfully violated my rights by going through my private property. He in the documents that he's brought up, were, like you just stated, they were not valid and they were canceled. So, like I stated before, I was traveling. I'm not a driver. I reserve all of my rights.
Mr. Garinger, do you have any questions for this witness?
No questions, Your Honor.
I reserve all of my rights under UCC 1-308.
I'm sorry, UCC, I need to be able to hear you clearly. You reserve all of your rights under
UCC 1-308.
Okay.
I do not accept this offer. I do not consent to any proceedings. I'm not a United States citizen.
Mr. Brown, I'm gonna stop you right now. You can have a seat. Any closing arguments?
Yeah, just briefly, just very briefly, Your Honor. Thank you. Your Honor, we heard testimony today from Corporal Spidell, an officer with Detroit Police Department for approximately 25 years, who has had extensive training in traffic enforcement and conducted over 8,000 traffic stops. That he was on duty on May 12, 2023 at approximately 2 p.m. near the intersection of Livernois and Warren in the city of Detroit, County of Wayne. While he was there conducting traffic enforcement, he spotted a vehicle while he was in the gas station that had expired tags. He was able to see that while he was in his squad car. Consequently, we heard testimony that Corporal Spidell then proceeded to do a traffic stop, pull that vehicle over, and conduct his stop and investigation. When Corporal Spidell went over to that vehicle, we saw on Corporal Spidell's body camera that he asked the driver of that vehicle to produce a copy of their insurance, registration, and a license, a Michigan license. The driver was unable to do so and refused to exit the vehicle when Corporal Spidell instructed them to do so on his first instruction. Corporal Spidell also instructed the driver to place their keys on top of the vehicle for safety. The driver of the vehicle, we heard testimony from Corporal Spidell that the driver of the vehicle did not do that, disobeying the lawful order of Officer Spidell. Your Honor, throughout this whole investigation, Corporal Spidell did eventually find a Michigan driver's license on the defendant's person, which he ran through the Secretary of State. We saw that in the body camera, as well as through the Secretary of State exhibit that the people admitted. However, by the defendant's own admission, he canceled his own license. He did not have a valid license on May 12, 2023. He was not able to produce one, nor did he have a valid title, nor was he able to produce one. Your Honor, I believe you have a copy of the MCL code, so I won't go through reciting them all. But it is required in the state of Michigan that if you are on the roadways, that you must have a valid driver's license. It's also required that you're in your motor vehicle, you must have a valid title to that vehicle and registration. Finally, if you're given a lawful order from a police officer, you must obey those commands if they're a lawful order. The fact of the matter is that the defendant, Mr. Roman Brown, did not produce those things when he was stopped on May 12th, and he refused to comply with the lawful orders given by Corporal Spidell. Therefore, the people would ask that this honorable court find the defendant guilty on all three counts. Thank you, Judge.
Thank you. Closing arguments from Mr. Brown.
Approach the
Yes, you may.
he gave me a ticket for speeding. Clearly, on video, it just showed that he said that he put me up for.
We don't have a speeding ticket on the record for today.
For a lawful order to be submitted, it had to be a crime being committed. There was no crime being committed. Like I stated before, I was traveling in my automobile, my private conveyance. I was not driving. I am not a driver or an employee like Uber or someone that's transporting goods or property. I'm not a driver. I was traveling from point A to point B. My automobile was, I had an issue with my automobile. It was stored. I was taking it to get it serviced. I was traveling there. I didn't commit any crime now. Well, like I stated, a lawful order for it to be a lawful order, it has to be a crime present. And I haven't committed any crimes. I did everything that he requested. I gave him all of the documents that were legit on my behalf. He went in my and unlawfully violated my rights by going into my private my private property and getting any information, the documents that he did get. And I didn't present those because they weren't valid. It wasn't they were canceled. So I don't want a contract. I do not consent to any contract. I don't want a contract. I have the right to travel free. I'm a non-citizen national. I am not a United States citizen. I am not a resident. I do not reside in any fictitious address in the United States. I'm a national for the United States of America Republic. I have the right to travel. And for the record, I need you to recite your oath of office to uphold my the Constitution. I haven't done anything wrong. I'm getting pulled over and took out of my car. That's like kidnapping. I wasn't. This is crazy. This is.
Are you done?
This is Lisa Precinct. Purposely.
I'm sorry, can you speak that?
Lisa Precinct.
I don't know that I understood that.
This court is operating as a Nisi Precinct.
What is that?
Nisi Precinct.
Don't repeat the words. Tell me what that means.
Okay. This is a notice of Nisi Previous. A demand for judicial notice of Rule Lacey. Again, a Rule Lacey's court. Notice is hereby given on August 6th of 2024 at 8:30 a.m. or soon the matters can be held in courtroom of the above entitled court. Move the court to take judicial notice of the following. This is a demand for judicial notice of Rule Nisi within a Nisi court. This court, by being part of the Nisi precinct court system, must follow Rule Nisi, which is a quote, a Rule Nisi which all becomes operated in final unless caused by shown against it. Since the court can require compel performance which is only allowed in the court, which is enforced some type of contract. It is Hornwood law that all contracts are either equitable or admissible for enforcement purposes. based upon the foregoing, this court must take judicial notice that this court is merely enforcing some type of contract that will allow rule 19 to apply. Therefore, the court should dismiss this matter and the prosecutor does not produce, if the prosecutor does not produce content on proof with omission, evidence that the accused was involved in a actual being regulated with admissible evidence that invoked the authority of the court. Hearsay or presumption will not be permitted since this is a criminal trial which the accused justly demands due process secure to him by the state constitution.
So she ordered you to go immediately, whether you were going to drive your vehicle or not, and put the interlock device on your vehicle. Is that right?
That is correct.
Waiting, Judge.
And I'm sorry. Okay. And so that was reset. Did you make an appointment to try to get that put on your vehicle?
Yes, I did. I got with Smart Start and had to schedule a meeting. And I went to that meeting 2 days before I had court on August 2nd. And somehow that place in Denison, Shipman Communications, didn't have me in the system to have that interlock device installed that day. So I had to reschedule for the following Wednesday.
And your probation, the person you report to at probation was able to confirm that and inform the judge of that. Is that right?
Yes, ma'am.
But she had also said you had to get enrolled at Freedom of Choice. Did you have an appointment to enroll at Freedom of Choice?
I did, yes.
Were you able to make that appointment?
I wasn't. It was the week before I had that court on that Friday. And so I called and had it rescheduled for that following Wednesday, the same time that I would get the interlock device put on my vehicle.
So the August 2nd court date, when Judge Blake revoked your bond, you were able to tell Judge Blake that, well, I'm sorry, August 2nd, when you were asked if you'd enrolled in Freedom of Choice and you told the court you'd had to move that appointment, is that when your bond was revoked?
No, I already did. I got enrolled the Wednesday before the 2nd, before I went to court. So I was enrolled into that class at that time.
So do you feel like your bond was revoked? Well, what is your perception of why your bond was revoked?
Well, I still don't really know why my bond was revoked, because I had, she ordered the scram device to be put on me in April when I left the jail, and I wore it for 4 months and never had a violation on it at all. And she pretty much revoked my bond because of a date discrepancy of when I needed to get enrolled.
Do you have confidence that going forward for your trial on the merits, that Judge Blake will be a fair and impartial justice to oversee your case?
No, I do not.
Is there any other reason, anything else you want Judge Cooks to hear?
No, just that I feel unfair in this whole court case. I know it's started as a DWI case, but it's turned into to violating my rights, and it feels like I'm guilty until proven innocent. And I've done missed a lot of work. I've missed the corn harvest. My boss had to actually call in a harvest crew to come in and combine our corn for us because I wasn't there to work. We're a small farm, but I mean, it's been really, really hard.
I pass the witness.
Mr. Hazelton?
Thank you, Judge. Mr. Head, in the beginning of this case, you initially had another counsel, right?
I did.
Okay, and what was that attorney's name?
It was Jackie Van Zett.
Okay, and at some time during that, you decided to represent yourself, isn't that true?
I did.
Okay, you also wrote letters to the court and you filed motions on your behalf, isn't that true?
I did.
Okay, and some of that you quoted about naval law and based some of your laws that you were basing these motions on, is that correct?
It was a conditional acceptance.
Okay, based on what kind of laws were you arguing in those motions?
It's the constitutional law.
Okay, what do you mean by that?
It's the actual law that comes from the Supreme Court rulings.
Okay, what were those motions you were filing?
What were they?
Yes.
It was just a conditional acceptance. I would accept what y'all are trying to get me to do with the DWI case. And if all I was asking was, for like your oath of office, Judge Blake's oath of office. I mean, are we still in what jurisdiction were we going to be in? That sort of thing.
Okay, and we had a hearing on this, and there were some issues during that where you disagreed with Judge Blake on her rulings. Isn't that true?
Not actually her rulings.
Okay, with the jurisdiction of the court, though, you took issue with the jurisdiction of this court.
Is that a ruling?
During the initial hearings we had, do you recall those, the first time you appeared on this court?
Yes, they're right.
Okay, and you took issues with her rulings about the jurisdiction of this court?
I did, yes.
Okay, and that's based on your beliefs of the Constitution that they didn't have this jurisdiction, this court didn't have jurisdiction over you, isn't that true?
I was trying to see which jurisdiction y'all had over me, and y'all would never give it to me.
Okay, what jurisdictions were you referring to?
The law of the land, a maritime law, that sort of thing.
Okay. You decide to represent your case yourself. Judge appoints Miss McDonald as standby counsel, and this case got set for trial. Isn't that true?
Yes, for June.
Oh, March, reset till March 14th. Doesn't that sound accurate for trial initially?
I didn't hear March 15th. I remember a June.
Okay. Sometime through that, you decide to let Miss McDonald represent you. Isn't that true?
Correct.
Okay. Your attorney filed a motion asking to clarify who was representing you. Was it going to be you representing yourself or Miss McDonald? And we had a hearing on that, correct?
Correct.
Okay. And during that hearing, Judge Blake asked you about, did you want Miss McDonald to represent yourself? Correct?
Correct.
Okay. And you told the court that you did want Miss McDonald to proceed in representing you during this trial.
Correct.
Okay. So the court didn't interfere with you represent yourself, true?
Yes, because y'all would never give me any time that I have a lawyer, I can't represent myself. Even with counsel, I didn't want counsel in this court.
Okay.
But with everything that had been done, I let Miss McDonald to go ahead and continue to be my lawyer.
Okay, we had a hearing on this in front of this Judge Blake, correct?
Correct?
Okay. Judge, may I screen share a few things at the moment?
You may.
And I'd ask the court to take judicial notice of everything in the court's file in this case.
Court takes judicial notice.
Can y'all see that screen?
Yes.
Okay. Mr. Head, this is your original magistration, your bond condition set by the court when you were arrested. Can you see it?
Yes.
Okay. Let's see, what date? Do you see a date of May 2nd on this?
I do.
Okay. Can you tell me which judge assigned these down at the bottom and signed your bond conditions initially when you were magistrated?
Ms. John Scottney.
Okay. Can you read me what number 8 bond condition is that he initialed next to?
I see it's the scram device.
Okay, so when you were initially ordered by Judge Scottnick, scram prior to release from jail. Mr. Head?
No, I went through my bail bondsman and he told me that there was none of that on there.
Okay, is this your signature here at the bottom on the signature line?
I don't sign my name with a JD head.
Okay, so that's not your signature on your magistration?
I do not sign my name like that, no.
Okay. Would you agree with me? You are James David Head, though?
You are saying that that's my name.
Well, what's your name?
I'm the beneficiary of James David Head.
What do you mean by that?
I'm the beneficiary of James David Head.
Okay, what's your driver's license name reflect on your driver's license?
The same as what you have here.
Okay. And you were arrested and magistrated on May 2nd, 2023?
Correct.
Okay. So there were multiple bond conditions, including a deep lung device. When did you get that installed on your vehicle?
I was going to get that installed after my last court hearing.
Okay. You got arrested in August of 2024. Had you gotten a deep lung device installed on your vehicle in this over the year time frame?
No, I haven't.
Okay. You also had conditions. Let me see if I can show you. Looks like we had bond violation filed on you June 27th of 23 for failing to attach a scram. And that was filed by the bond supervision department. You remember that warrant when you got arrested on that?
No, that was February when I got arrested.
How many times have you been arrested on this case, Mr. Head?
On this case?
Yes.
It's 2.
Okay, and what were those for?
For these bond violations.
Okay, and what was your first bond violation?
For not having a scram.
Okay, what was your second bond violation?
For the way I take it is I didn't get the lakes, the FOC classes done in a timely manner.
Okay, when were those conditions added on to you?
That was in July.
You were ordered lakes significantly earlier, correct? Mr. Head?
Sir?
Just so the judge we're aware, lakes and freedom of choice, these are to treat and make sure you're staying sober. Isn't that true?
Correct.
Okay. And those were ordered on with Judge Blake in this case early on, last year over, correct?
I had the scram device on since April and never had a violation.
Okay. How many times have you been to court regarding your bond conditions and trying to modify them?
Several, I don't know the actual number here.
Okay, and when you've come to court, what have you been requesting of the court to do for modifying?
For the classes, for the freedom of choice. I mean, I said I would be fine with the AA online. I was doing those. Had the scram device, had no violations on it for 4 months.
Okay, and we had that hearing, and you informed the court that you did not have a deep lung device. Is that true?
Yes, that is correct.
And that was June 12th of this year?
Yes, because I had to make an appointment to get that device installed, and it was like July 18th by the time I could get it. Or it was July 18th when I got the actual meeting, and then it was the August. No, it was July 28th. It was the Wednesday before I went to court on that Friday of August 2nd that I was supposed to get it installed.
Okay, and this was a bond condition that was ordered on you in May of the prior year, correct?
The way I understood it from my bail bondsman, that I didn't have any bond provisions. All I had to do is check in, and I checked in that whole time, and I never got a bond violation when I checked in.
Okay.
And even without having a scram device with the bond supervision.
I'm not threatening you. Say one more word and that's 30 days. 30 days.